great for me personally, getting involved with the Memphis World Trade Club. So that being said, it is 11:31, and we do have people joining us here. So I'll go ahead and get us kicked off. So welcome everyone to our April virtual luncheon series. And today we have Lyons, who is an attorney and shareholder with Glassman, Wyatt, Tuttle, and Cox. And we are extremely excited to have Lewis with us today. I think it's going to be really educational for our members and audience. So glad that you're joining us. Before we get started, I'm going to just do a few club announcements here. So I'm going to share my screen and hopefully I do this correctly. So Lewis, can you see the website here, Memphis World Trade Club?
Yes.
Okay, good. I just want to confirm that our members and audience could see that. So the first thing I'll say is that the Memphis World Trade Club is a really great organization. If you're in global supply chain and logistics in Memphis and you touch it in any way, even if you're not in the Memphis area, if you're in Little Rock or Nashville or Jonesboro or wherever you may be, we'd just like to encourage you to become a member of the Memphis World Trade Club. I know for me personally, it's been great. I've been involved with the organization for 5 or 6 years now, and I'm now the president in 2021. So I'm really fortunate to be a steward of this club that has been going on since 1947. But we provide really great educational and networking opportunities. And again, I'd just like to encourage you to join if you're not a member. And it's really easy to do. You can just go to memphisworldtradeclub.com and click on join today and just fill out a few basic details, select your payment method, and you're good to go. So also we are really excited to announce that our annual golf scramble is on for June 17th at Cherokee Valley Golf Club, and tickets are now available for purchase. And we've already have a few people and participants signed up and registered, and so we're really excited about that because we had to skip the golf scramble last year due to COVID, and this is going to be our first in-person event since 2019, and we are really excited about that. And we just want to have you guys come out and have a good time. A couple of changes this year. We have reduced the ticket price to $100 per individual and $400 per team. We'll not be serving meals at this scramble just due to COVID, and we've also reduced the price accordingly. So grab lunch on the way out there, and you're also welcome to purchase refreshments from Cherokee Valley and their snack bar, but we'll also be providing drinks, complimentary drinks, and other things for you guys. So come on out and join us for the golf scramble on June 17th. It's going to be really awesome. And then just learned, save the date. We're going to have a Choosing Transportation Summit on May 21st with the University of Memphis. And we're going to have pretty much an all-day program on, I believe it's Friday the 21st. So be on the lookout for announcements from the club on that. So I'm going to stop sharing here. Last thing I'll say is my internet connection has been a little bit unstable this morning. So if for any reason, I drop out, just please feel free to carry on, and I'll sign back on a little bit later if that happens. We do have a technology risk here, but we'll get through it either way. So without further ado, I'm going to introduce Lewis, and Lewis, after that, it'll be all yours. So today we have Lyons, who's an attorney and shareholder with Glassman, Wyatt, Tuttle, and Cox. And Lewis has been with the firm since his graduation from law school. And during that time, Lewis has assisted both corporate and individual clients in a variety of areas. He was born in Shreveport, Louisiana, and he moved to Memphis in 1998 to attend Rhodes College. And we were fortunate because he decided to stay in Memphis, and he graduated from law school at the University of Memphis in 2005. And Lewis's experience is really diverse, but his focus and his practice is on premises liability, transportation litigation, and legal malpractice defense. And he's been appointed by state and federal courts as guardian ad litem for more than 60 minor children seeking settlement approval. Lewis has tried, including as lead counsel, commercial and personal injury cases and jury and bench trials in state and federal court. Again, we're thrilled to have you today, Lewis. and looking forward to your talk. So the floor is yours.
Thanks, Daniel, and thanks for everyone for being here today for this virtual lunch with the Memphis World Trade Club. As Daniel said, my name is Lyons. I have been an attorney here in Memphis for 16 years. My practice is diverse, but primarily we do handle at my firm transportation litigation. We have been charter members of TIDA, the Trucking Industry Defense Association, as well as the Transportation Lawyers Association and various other groups. So it's nice to be here today with the Memphis World Trade Club. I'm going to see if I can you'd think that I would have learned how to do PowerPoint and Zoom at the same time by now, and I'm getting close to see if I can share my screen. I think we're there. So today we're going to talk I'm going to talk to you about litigation that involves transportation the transportation industry. And what we'll be talking about are basically accidents. So what we won't be talking about today is maritime, air, and rail. I know those are different modes of transportation that everyone deals with from time to time, some more than others. They all have some different nuances in the laws, and it's really, given the length of today's talk is relatively short, we kind of have to focus it a little bit. So we're not going to be talking too much about those areas, but we will be talking about motor carrier transportation, cargo claims within that context, personal injury claims. We're going to talk about who can be sued and for what, and talk about the theories of liability that companies bring against who, and the defenses that are available when a company finds themselves on the wrong end of a lawsuit, if there is a right end, I guess. Finally, we'll kind of wrap it up with talking about how to mitigate and control the risk and limit exposure, and generally steps that can be taken to respond to an accident after it happens. I'm going to try not to bore everyone too much with the details of the legal theories and defenses. They can get complicated, as you can imagine. We are dealing with pretty sophisticated environments typically, but that's what's interesting about this geographic area, is that there is a wide variety of players. And so we're dealing with simple, single truck farm operations, all the way to corporations like FedEx and UPS and Schneider that are running significantly more freight than some of these others. So we'll talk about who are the players and whether or not anyone gets sued after an accident. All of these people are going to have a stake in the game and have an interest in the way the claims are processed. So obviously we have the shipper who's going to start the process of getting a good from point A to point B. A broker may be involved to handle facilitate that transportation. The broker is going to choose a carrier to transport that cargo. There may be intermodal containers and providers involved. Obviously in Memphis, that is a big part of the transportation industry here. There's going to be lessors of equipment and lessees of equipment that can find themselves involved in litigation when accidents occur. Owner operators and company drivers also frequently find themselves as defendants when they're the operator of the truck that gets into an accident. And then certainly the customer consignee has an interest in the fact that their goods may not have arrived on time or arrived, if at all, damaged. So those are the types of folks that we have in the game. And when I was putting this presentation together, I was reminded of the story that I'm sure many of you have heard about everybody, somebody, anybody, and nobody. And you can read on your screen. I'm not going to read it to you, but you get the gist that there's the more people that there are involved in a process, the more hands that touch these goods, the more blame or potential blame there is to go around. So often what we deal with as transportation lawyers is trying to determine as quickly as possible and as efficiently as possible where the liability rests, if there is any liability, and how it may be shared amongst the various players. As you might expect, the more sophisticated operations are going to have motor carrier agreements, contract carriage agreements that shift liability. There may be insurance requirements, there may be indemnity provisions, and all of that is, of course, designed to pool risk, share risk, mitigate risk, shift responsibility for potential losses. And those, of course, can implicate cargo claims as well as personal injury claims. And so today, that's what we're going to talk about is a situation that occurred that is based on a real world example. We've all heard the adage that truth is stranger than fiction. So I pulled up a case that we actually handled a while back that would provide a real world framework for how these lawsuits can be how they can play out, how different companies respond, and the importance of having a quick and rapid response after an accident. So in this case, there was an owner-operator truck driver that was pulling an intermodal container down the interstate. He got loaded in Memphis and was on his way to another state when he, on the interstate, when he crossed the center line, colliding with a pickup truck. And unfortunately, the gentleman in the pickup truck was fatally injured and killed instantly in the accident. I've changed the names of everyone here just to protect the innocent, as they say, but the facts and the legal theories and defenses that we're going to talk about are very much real. So this shipment was a bunch of wine. It was a less than full container of wine that was coming from California. It was going to make its way to Alabama. It came by rail to a facility in Memphis, where it was loaded on an intermodal container and chassis and taken away by this truck driver to its point of destination when the accident occurred. As you can imagine, the wine was pretty expensive. We weren't talking about a bunch of cases of silver oak, luckily, but it was still a high quantity of wine, if not quality. At any rate, the cargo was destroyed. There was a total loss of all of the equipment, and you can see there, which this is the actual power unit that was carrying the intermodal container, and that's what was left of it. Fortunately, the driver, we'll talk more about him in a little bit, but he was not terribly injured in the accident and was able to get out of the cab before it became fully engulfed. The cargo there, you can see, was completely destroyed, as well as the containers and the chassis were burned beyond repair. So as you can imagine here, the tragedy was the loss of life of the individual, and that was true from a human standpoint as well as a dollars and cents standpoint. So the cargo claim here we'll talk about, but that was certainly not the driving force behind this litigation. And in fact, the cargo claim was resolved relatively quickly while everyone focused on the wrongful death claim. So as you can imagine, I've talked a little bit about the different players that were involved here and the number of people and companies involved. So we had a shipper in California. We had a broker that arranged for transport. We had an intermodal cargo container owner and lessor. We had a intermodal chassis lessor. We had a truck driver, and we had the motor carrier under whom authority that truck driver was operating. So the question is, with respect to the wrongful death case, who sued whom for what? The estate of the pickup driver understandably filed a lawsuit on behalf of the wrongful death beneficiaries of the estate. And the question is, who did they sue? And unfortunately, with this being a Zoom conversation, I can't pick on people and call on you to offer your suggestions. So a lot of my questions will be rhetorical, but as you can imagine, just about everybody got sued. This is essentially what the complaint looks like. Again, I've changed the names to protect anyone that may be here today. But the driver was sued. The driver's carrier, and he was an independent contractor / owner operator. But there will, and again, we'll talk about independent contractor stuff in a minute. But for legal purposes, he was an employee of the carrier. The broker was sued. The chassis owner was sued. The container owner was sued, and the shipper was sued as well. And there was another broker that was involved in some of the selection of one of these other brokers, but I left them out just to try to keep things a little bit simple. So believe it or not, this was not the only lawsuit that came out of this accident. So we'll talk to you a little, and we'll get to that in a little bit. There was a lawsuit that was filed against the estate of the wrongful death person, believe it or not, even though he did nothing wrong. But the insurance carrier for the broker filed what's called a declaratory judgment action against the insurance companies for the carrier and the chassis owners and the estate, as well as those companies themselves, to determine who was on the hook for any additional coverage over and above the coverage that was maintained by this driver and carrier. So that was the second of the lawsuits. The estate also filed a lawsuit in state court in Memphis against some other entities that are not transportation related, and we'll get to that in a second. So I share all this to make the point, when these accidents happen, lawyers in this day and age, plaintiffs' lawyers, are litigious and will come after everyone for anything that they can. That's just a reality of the situation that we find ourselves in this country today. And it's something important to think about. So you may be asking, what caused this truck driver to cross the center line and run into a truck head on while going down the interstate? And that, in fact, is the multi-million-dollar question in this case. As it turned out, there was an issue with this particular driver's health history, and the estate of the wrongful death estate alleged that the driver who was a 55-year-old male, had a history of chronic severe hypertension, diabetes, and severe coronary artery disease. And as it turned out, it was determined after he went to the hospital and was evaluated that the truck driver had a stroke while driving, and that is what caused him to lose control of the accident. So the question is, whose fault is that, if anyone? And could anyone or should anyone have foreseen that this fellow may have been likely to have a stroke or likely to have some other heart attack that would cause him to lose control of his vehicle while going down the road? So the theories of liability that were advanced by the plaintiff it can be characterized in basically two categories. What we call direct claims for negligence. Those are meaning that they're brought against the person who is claimed to have been negligent or at fault. So the direct claims would have been those, obviously, against the driver for failure to maintain control of his vehicle. The carrier was sued under the theory that they were negligent in hiring, supervising, or retaining this particular driver, but they didn't do enough to evaluate his health history and should have known that he was not qualified to drive the vehicle. The logistics companies, and that's what I'm going to refer to as the chassis and intermodal container. Well, I'm sorry, I skipped ahead. The broker was sued for negligent selection of the carrier and negligent entrustment of the load. In other words, if the broker hadn't picked this carrier, this guy would never have been on the road. They sued the logistic companies under a similar theory that there was a duty on the part of the chassis owner and chassis container owner to provide, to evaluate who they're going to let haul their equipment, and that if they had done their job correctly, they would have not given the load to this guy, and this accident would have never happened. The shipper was sued under a similar theory, and those are all claims, again, that the plaintiff alleged that these different companies were the ones that were responsible for these actions directly. They also sued all of these companies on the basis of what's called vicarious liability. In other words, because you have a principal or agent relationship with this truck driver or with this carrier, where you're going to own any liability for accidents that they caused in a vicarious sense. So there's two different categories of claims. One of them, and a principal can be vicariously liable for the acts of an agent, even if the principal itself didn't do anything wrong. So in other words, if it may not have been foreseeable to the carrier that this gentleman would have had a stroke while he was driving down the interstate, and that's fine, that means they will not be chargeable with negligent hiring or negligent supervision, negligent training, things like that, but they can still be liable for the accident because employers can be liable for the actions of employees committed within the course and scope of their employment. So those were the basic theories of liability that were set out in the case, in the lawsuit filed against the transportation companies by the plaintiff. So what defenses were available? Well, we represented the driver and actually several other of the players based on some of the indemnity agreements and contracts that existed between them. But our primary argument with respect to this driver is that, look, if he thought that he was going to have a stroke while he personally was driving a vehicle down the road that would put him at risk, the likelihood of him knowing that that was a reasonable probability would seem to suggest that he did not expect that he would have a stroke and cause himself to drive off the road. So there is defense in most states, and again, these are state law claims, not federal law. There are federal law implications that we'll talk about, but the common law negligence claims that we're dealing with here are all based on state law. So there are some differences. In my firm, we handle cases in Arkansas, Tennessee, Mississippi, Kentucky, Alabama, even some in Missouri, but not that many. So the state law changes and there's different nuances, but in general, every state has a similar type of negligence law, and that means that there has to be a duty owed to the person who's injured, that there is a breach of that duty or someone acted in an unreasonable way and that caused someone to suffer injuries. And those are basically the four elements of negligence. So we said that, look, this was a sudden and unforeseeable medical emergency that rendered this driver physically incapable of maintaining control of his vehicle through no fault of his own, and that there should be no liability. The carrier, with respect, so that defense would flow up the chain and would be a defense for the carrier with respect to any vicarious liability claims. If the agent is found to have a valid defense, that's going to inure to the benefit of the principal. Now, the carrier, with respect to their negligent hiring or negligent retention claims, they did their due diligence. This driver had a valid CDL. He was properly authorized in accordance with the Federal Motor Carrier Safety Regulations. He had a valid DOT medical card, and there was no reason for them to anticipate that this would happen. So their carrier's argument was that this was an unforeseeable event from their standpoint. The broker, we did not represent the broker, but the broker argued that, look, this carrier had good CSA, CSM scores. The carrier was an independent contractor of ours. We did not exercise control over that carrier. We're going to talk about some of these issues in a minute because I think there's some practical aspects here that are interesting and maybe of interest to some of you. But they did everything that they should have done and selected a carrier that they thought was duly qualified under federal law and federal regulations and had a good safety record. The logistics companies, the chassis and container owners defended under the Graves Amendment, and that is a federal statute that provides that the owners of equipment that are involved in an accident whose only relationship to the accident is the ownership of the equipment won't be held liable. And therefore, under a doctrine called federal preemption, that they can't, plaintiff cannot bring state law claims against a owner of equipment whose relationship to the accident is solely the involvement of their equipment. There is a new trend emerging in defending brokers in these types of cases, and that is another federal law, the Federal Aviation Administration Authorization Act, which provides some protection to brokers. And there aren't a lot of cases from this geographic area, but that's another defense that's emerging and that was asserted by the broker in the case that we had, but the judge never ruled on it before the case was ultimately resolved. So we did not, what we thought we might get a good test case out of, as often happens, the case was resolved before there was any new law to come out of it. So talking about what brokers can do for in terms of mitigating their risk and avoiding these types of complaints has a lot to do not only with preventing accidents and setting up good defenses if there's a lawsuit, but a lot of these things I'm going to talk about in a minute right now are will help provide better service to their customers. Obviously, the more downtime there is, the more delays there are, the more frustrated the customers get, and problems there can be, and the more stress for the broker who's trying to get his truck from point A to point B. So one of the things that can be done, of course, that I'm sure many of you know about, is the Compliance, Safety, and Accountability Act is part, or Compliance, Safety, and Accountability program that the Federal Motor Carrier Safety Administration has. And they talk, they basically, you can go on SaferWeb and do what we do a lot of times is look at company snapshots. You just plug in their DOT number and it gives you some information. If that is done, it can be a good way to keep tabs on the types of companies that you're trusting loads with. The things to kind of keep an eye on, in addition to just their safety scores and the number of accidents, how often, especially if this is a carrier that you've done business with for a while, do they change their DOT number periodically or frequently, and get different authority? That's can be a red flag for any number of reasons. Some that may have to do with safety, some that may have to do with financial distress or other reasons that could be a red flag. What is their service history? Do they have a lot of breakdowns? Things like that obviously will be important to know, and that can have an impact on safety as well as providing timely service. The amount of control that the broker has over the carrier is extremely important. How often does the broker send a message or a phone call to the driver or to the carrier to check on the load? Do they place any restrictions or specific instructions? The more involved the broker is in how the carrier and driver transport that good, the more likely there is to be an argument that there is a joint venture, or that there is not really an independent contractor relationship, but one where there is a chance to increase the likelihood that the broker can be on the hook for vicarious liability claims. So those are some aspects about the broker's role in choosing a carrier. Again, looking at things like the safety record, the way that the CESM scores are developed. They look at unsafe driving, including speeding, reckless driving, etc. Look for incidents where there's been logbook violations. Are there numerous out of service issues? They'll look at, particularly in the case that our example that we're talking about today, driver fitness, issues with driver qualifications, whether from a medical standpoint or otherwise. Is there an issue with drug test or random drug test issues, things of that nature? And then vehicle maintenance is a big one too, in cases where maybe the brakes go out or the tires blow out. Oftentimes we have cases where there will be a disabled tractor trailer that doesn't get in a wreck, but he's had tires blow out or for whatever reason is on the shoulder of the interstate and someone hits him. Well, those cases can result in significant exposure for the transportation companies, even though they didn't do anything wrong in terms of causing an accident. The failure to maintain the equipment in good working order that prompted that breakdown can still be, in the legal parlance, a proximate cause of the injury. In other words, if you hadn't run retreads and bald tires on your trailer, they wouldn't have blown out or you wouldn't have lost control and this accident wouldn't have happened. So those are some things a broker can do to not only increase their responsibility and level of commitment to safety, but can help maintain good service to their customers. The cargo aspects of this claim is, I'm sure everyone is familiar with the Carmack Amendment, which is the part of the Interstate Commerce Act that basically says anytime that there is a cargo claim, the carrier is going to be the one responsible. Now, as you might expect, there are exceptions to every rule, and the Carmack Amendment is no different. There are specific circumstances when it applies and circumstances when it doesn't. For example, if a load is carried completely within one state, the Carmack Amendment is not going to apply. There also, again, this has to do with how the definition of motor carrier is construed, and there are situations in which even a broker has been determined to be a motor carrier for the purposes of the Carmack Amendment. So it's usually these are handled on a case-by-case basis, and it's again talking about the issues of control, and if sometimes brokers will have a motor carrier authority even though they may not even own a truck, and sometimes that will be used as an argument to suggest that a broker can be liable for a cargo claim. We talked about federal preemption. This gets really tedious and boring even for lawyers and law students, so I'm not going to dwell on it too much, but this is part of these emerging trends that are sort of interesting from a lawyer standpoint regarding the FAAA, the Aviation Act Authorization Act that we talked about earlier, in determining that if a broker is if there's an accident and a broker is not deemed to be clearly related to the freight broker's role in the transportation of property, they're going to be protected by this federal statute. And there are 3 cases. I believe all these 3 cases are out of Illinois, but you can see Global Trans Enterprises, and then 2 involving C.H. Robinson, where the court concluded that state law negligence claims are not going to be able to be brought against brokers because it would hinder the objectives of the federal law, and that these would include vicarious liability claims as well as claims for negligent hiring and negligent selection of a carrier. So these are, again, that's about the extent that I'm going to get into the details of the legal theories. But after you have to suffer through about federal preemption talk, we'll do a trivia question. And I've got a fancy hat that I think my wife must have taken out of my office, but I've got a Glassman, Wyatt, Tuttle, and Cox camouflage hat for the winner of the trivia question. And you can just either leave it in the comments section of the Zoom here, if that's enabled, or just send Daniel an email. And anyone who's the first one to know on what date the Hernando de Soto Bridge opened to automobile traffic. And we'll get the Jeopardy music going and give people some time to think. And the answer, August 2nd, 1973. So it's been it's funny to hear someone who, like myself, was not even born then, that for that to be called the new bridge. Still, I still get a kick out of that. All right. Well, as we continue on, we talked about the multiple lawsuits that were filed by the estate of the deceased pickup truck driver in this accident. As you can imagine, there was a big issue about his health history and the fact that he had a valid DOT medical card that was issued by a physician after a complete physical. So there was some indication, and a lot of investigation was done into this driver's health background. It turns out that he had had a pretty severe heart attack a couple of years before this accident, but had improved, had not had any issues for a number of years after that heart attack. And then also the stroke, of course, is not necessarily a coronary event as much as it is a neurological event. So, but there are still questions. So the family, the estate of the deceased pickup truck driver sued the doctor and the healthcare clinic that did the DOT medical. That case is actually still in litigation today in Memphis. And this accident happened back in 2017. So and as I alluded to earlier, there was also the insurance company for the logistics companies sued Mr. Public's estate, the carrier and the driver. That case was ultimately resolved about a year after the underlying case was resolved. So I say that to say that there are a lot of facets to these cases. They can also take a long time. This one, because of the nature of the accident, was not too significant in terms of investigating who, did someone turn left in front of somebody else, and how fast were they going? Were they speeding? Who ran the red light? This one was cut and dry. There was no doubt that the driver ran across the median and hit the other car head on. But there are still important roles, important information to be gathered soon after an accident. So as we get towards the end of our talk, we'll talk about the role of the transportation attorney in responding to an accident, and the role of the various companies that can be involved, and what's important for them to do upon finding out about an accident. So as you can anticipate, there are numerous bits of evidence that can vanish very quickly after an accident. So it's important that you get a lawyer there quickly. The lawyers have relationships with accident reconstruction experts that will help to investigate the accident and preserve evidence. The importance of having the ability to measure a tractor that's been involved in an accident, to do a crush analysis, to help determine speeds, things of that nature can be important. Preserving the weight information, usually that can be pieced together by paperwork, but if the paperwork is burned up or there is not a good record, it can be important to go ahead and get the vehicle cargo and everything weighed, because that's going to be important in determining speed differentials and things of that nature. Spoliation letters are letters that come from plaintiff's lawyers, often very quickly after an accident, particularly a severe accident, that can have significant implications for putting a company on notice to preserve evidence, and the failure to preserve evidence after receipt of a spoliation letter will potentially result in sanctions and some pretty bad news in the litigation if evidence is not maintained, even if it's not actively destroyed because someone's trying to hide something. The failure to preserve it can lead to some bad results, and the importance of document retention at the early stages is key. Now, we talked about accident reconstruction expert. They are really incredible, and I was going to try to show y'all some videos, but I couldn't put my fingers on any of good ones that aren't actively being used in some cases that we're doing right now. But they can put together some really incredible models, 3D computer animations and things like that really illustrate how accidents occur based on physical data that they collect. But they can't do those models, or the models won't be admissible in court if they're not based on sufficient and reliable data. And so the importance of finding the evidence and having an accident reconstruction expert out there as quickly as possible is critical. Oftentimes accidents occur at night, so there's an issue of, well, he didn't have his headlights on. These experts can tell if even if the headlight's busted, whether the filament was hot, so to speak, at the time that it was broken. Things of that nature. So the quicker that's done, and the quicker the accident reconstruction expert can make the scene while there are still fresh skid marks, still fresh paint from the highway patrol that does their investigation, things of that nature, broken branches on trees, anything that they can use to provide a data point is going to be important, and getting it quickly. The preservation of physical evidence, again, it goes kind of hand in hand. What you see here is a ECM download, is what we call it, but from the truck's computer will have various degrees of information. Most importantly for us is critical events or sudden deceleration reports, which can tell you in pretty much detail what the speed of the vehicle was, the RPMs, things of that nature, and tell you at what point did the driver perceive a threat, and what time, how long did it take that driver to react. And those pieces of data are tremendously important to have in a case like this. Some of the other things that are important to preserve after an accident, and what we do, and I keep a neon vest in my truck because it's not uncommon to be called at 6 o'clock in the evening to say, oh, you need to go out to Lamar, there's been a wreck. And so one of the things that we do is make sure that we take an inventory of the contents of the tractor. Most likely we're going to be representing that truck driver, and if he's got a bottle of Boone's Farm under his seat, that's something that we need to know and document. And having the lawyers there quickly will often provide protection for different statements that might be made. It cloaks some of the statements with attorney-client privilege and things of that nature. We're also able to be there when the drivers give statements to the police. Oftentimes, if there's a fatality, the drivers will actually come into the police precinct to give a statement, a written statement, and it's important that the attorney be there for that because it's a situation where they need counsel, and it's helpful for the company. Again, paperwork is important this day and age with electronic logs and GPS tracking. The old log books where you fill out the lines on the J.J. Keller pages are kind of going the way of the dodo, but still there are document retention requirements for under the federal regulations. So it's important that all of those ducks are in a row. This is an example of a checklist of some things that we will look at in responding to an accident. And so again, it's just getting complete information from the driver, getting as much information as you can, retaining an accident reconstruction expert if the case warrants it. Those guys aren't particularly cheap, but and so if it's a case where someone's rear-ended your trailer, there's no damage to either car, and everyone walks away, those probably are not the cases where we're going to deploy a rapid response team and that needs a lawyer and an accident reconstruction expert to go out and to the scene. But in cases that are more severe, those are definitely necessary. So I think we're kind of coming close to the amount of time that we have today. I think I've got about 35 minutes or so. I think I've gone over, but if there are any questions, I'll be happy to answer them. And if anyone wants to know any more details about any of this, just let me know, and I can provide my email address or any other contact information. But Daniel?
Yeah, thanks, Lewis. Actually, we do have a couple of comments and questions from Stan Shoemaker via chat. And he highlighted a couple of items you mentioned. Number one, the indemnification clause of the contract. He asked, don't most states have anti-indemnification laws?
They do have anti-identification laws in certain contexts. In Tennessee, there is not one that would prohibit an indemnity agreement in a case like the one that we talked about today. So you're free to contract away your liability in certain situations. For instance, the freight broker might have an indemnity agreement where the carrier indemnifies the freight broker in the event of an accident. That's fine. What you can't have is that there's some way, and there's certain contexts, and it varies by state. For instance, in Tennessee, there are certain rules with respect to like home inspections, and if you have someone's building your house, the general contractor can't say, well, you're going to release me of all liability that may ever happen. So in the transportation context, indemnity agreements between players on the transportation end are fairly common. But again, different states have different rules. So depending on the state that you're operating in, and which usually is going to be many states, and that's one of the issues that can get tricky for lawyers, is to determining, okay, which state's law is going to govern. That's why most of these types of contracts, the more sophisticated ones, will include a choice of law provision that the parties can agree upon. That this, even though I'm in Ohio and you're in Tennessee, we're going to pick Tennessee law to apply to the agreement. And so I hope that's helpful. But it's indemnity agreements in the transportation context are pretty common.
And would you say in general that they carry weight in the courts, or is it just really depends?
Well, they teach you in law school that the best answer to any question regarding the interpretation of law is it depends. And but no, oftentimes it doesn't even get litigated. For instance, in this case, our example case today, we represented the driver, the carrier, and the intermodal container owner and the intermodal chassis owner. We also provided indemnity to the broker, but the broker did have a separate lawyer because there was potential conflict. But the insurance company that we were retained by the carrier's insurance company, and they accepted the tender of the claims by those other entities pursuant to the indemnity contract. So there was those were so certain that it didn't even get to a point where they had to be litigated. The declaratory judgment action that was filed by the logistics company's insurance company was to address any liability over and above the limits that were maintained by the carrier's insurance company. And that case ultimately got settled. So they do carry weight. Had those indemnity agreements not been there, our role would have been different. There would have been a lot more lawyers involved and potentially exposure for the broker that wasn't there by virtue of the indemnity provision.
Okay, excellent information. Okay, Stan also mentioned that you mentioned the Graves Amendment, and he said there seems to be a trend now with plaintiff PIA going after the largest party involved in an accident. For example, if you have a trailer interchange agreement with Amazon and owner operators pulling an Amazon trailer, they would tend to go after Amazon as well due to their deep pockets, regardless of any interchange agreement in place with trailer ownership or who has control of the equipment.
That's true, and there's an old saying, and I hope it's not offensive, but someone can sue the Pope for being Jewish as long as they can pay the filing fee. Okay, my wife told me, I was trying to come up with a different example, but she said maybe you can sue Fred Smith for using UPS as long as you can pay the filing fee. But the point is, you can sue whoever you want for whatever you want as long as you can get in the door. And unfortunately, there's a lot of people that plaintiffs' lawyers that do that. The Graves Amendment was designed to to insulate people or companies that have such little to do with the transportation aspect of it, or the selection of the carrier, selection of the driver to do that. And so it's an important piece of federal legislation that, again, preempts any state law claims. So even if a state, the Tennessee Supreme Court says, well, we don't think that Amazon should get that protection if in fact Amazon qualifies under the Grays Amendment. And again, there's a lot of exceptions as with everything in the law, but typically the higher up, when you get to the shipper and the intermodal owners, the lessors, and people that are parties to interchange agreements that have really nothing to do with who's driving that vehicle, how that vehicle is maintained, and what the safety record is of the carrier, the selection of the carrier. It is very rare, from a practical standpoint, that those companies end up paying out. For one thing, the minimum insurance requirements for motor carriers is high. There are many states, Tennessee being one of them, that has limitations on non-economic damages. That in a case like this one that we told you about, even though that was under Mississippi law, because that's where the accident occurred, we're still dealing with in Tennessee non-economic injuries. In other words, pain and suffering. The caps are $750,000. In a regular case, if someone is killed and has surviving children under the age of 18, it goes up to $1 million, and that's on top of any medical bills or lost wages. But usually the framework is such that there is going to be sufficient insurance at the lower levels, and only when it's insufficient, as in this case, will it be implicated. But we filed a summary judgment motion, the motion to dismiss based on the Grays Amendment on behalf of the intermodal container and chassis owner in that case. Fortunately or unfortunately, the case resolved without any contribution from those entities or their insurers before the judge could rule on it. But I thought it was a very, since I drafted it, a very well-written and well-reasoned motion that more than likely probably would have been granted. That doesn't mean that those folks aren't involved in 2 years of litigation, and that's the rub, is that it can be aggravating to even be named as a party, because even if you got protection of the Grays Amendment, you still may have to be 2 years invested in a lawsuit before it ultimately gets resolved. So.
Absolutely, yeah, and I think, like in so many cases, the answer is it sort of depends, right? But it does seem, like you said, in practical, in practice, the further away from the transaction, the sort of the less liability you're going to have. But I think it stands to reason that this is a really stark reminder for all of us that are involved in this business, that we are involved in a serious business, and we should always practice our due diligence when, whether you're a broker or a freight forwarder or trucking company, that you take precautions and to ensure everyone's safety. And this was a really great talk, Lewis. I really appreciate it, and it was really educational for all of us, and for myself included. So, and that's just a reminder for all of you that this webinar will become available on YouTube, hopefully soon. So if you want to go back and review it, and Lewis was also kind enough to share his presentation with us in PDF format. So we'll blast that out to all the attendees today, and you can share that. I think that's a really great resource for all of us. So with that being said, Lewis, thank you so much for your time and your expertise and knowledge as you shared with us today. It was really great. And for that, we want to offer you a complimentary membership to the Trade Club, effective today. So we're grateful to have you as a member of the World Trade Club. Really appreciate it.
Well, thank you. It was a privilege to be here to talk with you, and I hope that in the future we'll be able to do this face-to-face another time.
Yeah, absolutely. That did remind me of a couple of questions really quick that I had. So your firm, in this case, in the case that you highlighted, you actually represented a couple of the defendants, in the case, the driver and the motor carrier. Does your firm ever act as a representative of plaintiffs in some similar cases? Not in the transportation world.
We have some lawyers in my office that do medical malpractice for plaintiffs with people that are injured by doctors or nursing homes, but no, in the transportation world, we only represent transportation companies.
Okay, excellent. And I think it was kind of a recommendation that you had in your presentation that, should you become entangled in an accident such as this, it's probably important to council as soon as possible after that fact. Is that correct?
Yeah, and I probably should have mentioned, and maybe it goes without saying, but the notify your insurance carrier if you've got one. Hopefully you've got one, and they will that they will pick up that ball and run with it. And maybe it's important to implore them to do that and say, look, we need to get someone involved right away. Depending on who your carrier is, and whether they have anyone local, they may hire an independent adjuster, which can be a valuable tool. We work with them a lot, independent adjusters to maybe there's 2 accidents in one day and I can't be 2 places at once. Yeah, having counsel there quickly is important for some of the reasons that we discussed about attorney-client privilege and preserving some protections, as well as making sure that things are done correctly. Because frankly, there are, you saw the checklist that we put up. That's just a simple guide that we give to some of our clients. But first and foremost, you need to notify your insurance company if you have one, and depending on your policy, you may be able to select your own counsel or not. So call your lawyer and call your insurance company, not necessarily in that order.
Okay, good to know. Yeah, because I guess I would have thought, just as an assumption, you would have the ability to select your own, but that may not be the case depending on your insurance company.
That's correct.
Okay, good to know. All right. Well, thanks again, Lewis. Just want to remind everyone that we do have 2 events coming up soon with the Memphis World Trade Club in collaboration with the University of Memphis. We're going to have a Choosing Transportation Summit on Friday, May 21st. And then, of course, we're going to have our annual golf scramble on Thursday, June 17th at the Cherokee Valley Golf Club. It's going to be a great time. And we encourage you to all come out and have a great time with us. Get a ticket for yourself or a team. We also have sponsorship opportunities available for whole sponsors and beverage carts and so forth. So please take a look at that at your earliest convenience on our website. And I want to thank everybody for joining. And Lewis, thanks again. It was a great presentation, and hope everybody has a great day. Thank you.
Thanks, everyone.